Okay,
Everybody can mute themselves. That would be helpful.
so I'm Richard Hart. My career has been doing expert testimony in litigation for tribes. And in order to get through this, all of the subject, I think I ought to just get started with that. If you have any questions about my work or about what I'm talking about, please don't feel free to ask them. So in order to understand the rules relating to navigable bodies of water, first of all, I think we have to have a little bit of history about, unusually, about highways. The word highway came from Roman times, where the Romans built long roads, and they actually learned how to engineer roads properly, putting the crown higher than the sides so that the water drained to the sides, and then trenches along the edges of the road that we now call borrow pits or borrow pits, uh, because you borrow wood, you borrow dirt from there to put on the crown of the road so that it will be correctly structured. But by the time the United States was settled, by the time North America was settled, the term highway had been come to be used more for water. So the term highway was applied to rivers and lakes. And the reason is that the whole purpose of highways was for commerce. So when the United States was settled, when the United States, when the Constitution was signed and when the Declaration of Independence was signed, the founders decided that navigable bodies of water should be under and therefore highways should be under the jurisdiction of the federal government, not state governments. However, states, as they entered the Union, could have under them the authority to handle navigable bodies of water after the time when they became states. So the original 13 colonies that became the original 13 states initially took control over the navigable bodies of water within their boundaries. And as a result, the courts, in an effort to try and make things equal for the other states that would come in later, created what is known as the equal footing doctrine. The equal footing doctrine stated that in order for future states to stay on a par with the original 13, at the time when they became a state and became a part of the Union, any navigable waters that had not been previously reserved for other purposes by the United States became under the jurisdiction of the state. And so today, in the state of Washington, any navigable bodies of water that had been reserved prior to statehood remain under the control of the federal government or whoever, or in some cases tribes. Any navigable body of water that had not been reserved prior to statehood comes under the authority of the state. So with that in mind, one of the purposes for which the United States could reserve navigable bodies of water was for reservations. They could also reserve navigable bodies of water for military purposes or for wildlife purposes or for other purposes. So as the courts dealt with tribal issues, the Supreme Court of the United States eventually set out some tests to determine whether or not the United States intended to reserve navigable bodies of water that were within reservations. So there's a whole different discussion surrounding how reservations were established, but whether they were established by treaty or by executive order by Congress, the if there was a navigable body of water within the reservation, the Supreme Court found that in order for it to have been reserved for the use of the tribe or tribes, first of all, the tribe or tribes must have depended on the resource. And second, the Congress or the federal government, whoever set aside the reservation, the executive branch and Congress, had to be aware of the inclusion of the navigable bodies of water. And third, the conveyance had to be explicit. Just like reservations have to be explicitly created and explicitly removed, navigable bodies of water had to be, the inclusion of the navigable bodies of water within the reservation had to be part of an explicit conveyance. So that's a little bit of a background on all of that. So maybe I'll just pause. Are there any questions about that? None, and hearing none, I'll go on. I've got three cases I've done over the years that deal with what we call submerged lands. And I should mention also that the United States has the authority, or the states have the authority, to manage the water for commercial purposes, the navigable bodies of water. A whole different set of law deals with non-navigable bodies of water. So nobody owns the water, you only have use rights. And the United States or the states manage the use rights. What the United States does own or may have reserved for another entity are what are called the submerged lands. Those would be what we would normally call the beds and banks. So in the late 20th century, actually it had been going on for a long time, the Coeur d'Alene tribe had begun arguing that it owned the Coeur d'Alene Lake Coeur d'Alene. And the state of Idaho argued that it owned Lake Coeur d'Alene. And the federal government stepped in to litigate in behalf of the tribe. Now, the Justice Department ordinarily must represent tribes because the United States is the trustee for tribes. It must represent tribes if there is a dispute about real property. So if there's a boundary dispute or a water dispute or something dealing with mines, for instance, or minerals, then the United States has a legal obligation to represent the tribe. So in this case, what happened, what my role was, I was contacted by the solicitor of the Department of Justice, of the Department of Interior, to ask whether I thought there was a basis for the tribe to claim ownership of the submerged lands under Lake Coeur d'Alene. What this really means is, did the United States really reserve Lake Coeur d'Alene for the tribe when it set aside their reservation? So I did a preliminary research on the matter and sent the solicitor of the Interior Department, the attorney for the Interior Department. I sent the solicitor a short report in which I said there's ample evidence to show that the Coeur d'Alene tribe, that the United States did indeed intend to reserve the lake as a part of the reservation, and that at least a portion of that lake should remain as a part of the reservation. And on that basis, the matter was referred to the Justice Department, and the Justice Department informed the tribe that they would sue the state of Idaho over ownership of Lake Coeur d'Alene or over the submerged lands. So in order to explain this case, I'm going to have to give a little bit of history about how the reservation was established. The tribe was very isolated. It was pretty hard to get to where their main village was without crossing a large body of water and either rivers or lakes. And so when the United States sent a military expedition out to try and negotiate a treaty, they couldn't even get to the meeting place without the tribes taking them across the river in canoes. As a result, they were in kind of a weak position, and they did not cede their Aboriginal territory at that time. Later, by the 1870s, this was the first effort of the United States was in the 1850s. In the 1870s, the tribe eventually reached an agreement with the United States by which they identified what could be their reservation, which included all of Lake Coeur d'Alene. And that agreement eventually was translated into an executive order by the president, which created the reservation, which was ratified by the United States Congress. So the question came, so then what happened was there was a mining boom in the Kellogg area. I don't know if any of you have been over to the Silver Valley. Thousands of miners and prospectors and engineers were heading up into the Silver Valley for the purposes of the mines that were being constructed up there. And in order to get there, they had to cross the Lake Coeur d'Alene, on a riverboat, or a lake boat in this case, a paddle wheel. Well, the problem was that the paddle wheel, that the people that were running the boats began serving liquor to the miners. And the miners considered that it was really their basic right to have liquor as they reached the mining camp. And the problem was, if the lake is part of the reservation, then it is part of Indian country, and it was part of the laws that govern behavior in Indian country, and therefore selling alcohol to Indians was illegal. Well, this became a big issue for the miners and the river and the paddle wheel company, and eventually the issue was investigated by the Justice Department, and the findings were sent all the way to the President of the United States, and he had a cabinet meeting to try and determine what to do. And they decided the only reasonable way to deal with this was to get the tribe to cede a portion of the lake to the United States so that it had a right to serve liquor to these miners as they crossed the lake in the boat on their way to their mining fields. It seems pretty outrageous to us today that it would be such a little thing causing such a big uproar, but that was the case. So in the 1880s, the United States sent out a commission to deal with the tribe. And my position, what I believe, is that the chief of the tribe, whose name was Celtis, the last head chief or great chief of the tribe, and I thought he did a really great job of negotiating with the United States and got a good price for a portion of the lake and a small portion of land on the northern part of the reservation. The tribe eventually disagreed with me and decided that he had been coerced and that he didn't really make a good deal. I stuck with my testimony, and I still stick with my testimony, and I still believe I'm correct, that the tribal leader did do a good job, best he could do at the time, and actually got a very sizable cash payment for the day, about $500,000. So the question then became, well, did that include part of the lake or not? Were they aware of that? Well, it was very clear from the negotiations that they did intend to take a part of the lake. That was the whole purpose of the negotiations. That was the whole purpose of the session. And to prove it, there's a little town called Harrison that's right at the mouth of the Coeur d'Alene River, where it comes down out of the Silver Valley, where the miners were. And that little town was somewhat of a port for all of the ore that was coming out. And so it was important to the town that the port not become part of the reservation, or that it be part of the cession. So when the surveyor surveyed the cession line, the surveyor had 2 right angles out in the water protecting that protecting that harbor, so that that was part of United States property and not part, or ultimately part of the state's property and not part of the tribe's property. So the eventually in the 20th century, as I said, the United States sued the state of Idaho over ownership of the submerged lands. It went to court, and the lower court ruled that the tribe owned the southern portion of the lake, and the state owned the northern portion of the lake. And that went to the Ninth Circuit, which upheld the decision, and it went to the Supreme Court. And the Supreme Court ruled in favor of the tribe, and ruled that one of the key pieces of evidence was were the two right angles that the surveyor made out in the water to protect that harbor. The Supreme Court and the lower courts, I thought, did a really good job. And I would just stop to say the lower court judge was a Republican appointee. Of course, the Ninth Circuit is made up of both Republicans and Democrats. And the Supreme Court decision was the swing vote was a Republican appointee. So my experience with the courts has been pretty good, that no matter who appointed the justices, they've remained pretty true to the law. So the only big issue left was the United States clearly, were the Congress and the president clearly informed about the distribution of the submerged lands of Lake Coeur d'Alene prior to statehood. And as it turned out, there were several reports that went to all of the parties prior to statehood. And the Supreme Court ruled that the tribe did own the southern portion of the lake. I sat in the arguments. I sat in the Supreme Court and listened to the arguments. And one of the things, I think it was Sandra Day O'Connor, asked both the attorneys for both sides